Hello and good afternoon, everybody. Thank you for joining us for another one of our MAG specialist seminars. And today we've got a specialist from the other side, so to speak. This time it's not a doctor, but it's another one of the experts that we work with and that makes the services we deliver to our clients just that much better. Today we're joined by Heather Kerley from Maurice Blackburn Lawyers. She is an associate and the state leader for their abuse law business for Queensland and the Northern Territory. I've known Heather for many, many years and continue to be impressed by her practice as a lawyer and by her ethics and her professionalism as a person. We are absolutely privileged to have her present on this really topical issue. Sadly, we are seeing many more abuse matters coming forward. And whilst that's sad, I guess the good thing there is it means that people are feeling more supported generally to be reporting this sort of thing. So look, without further ado, I'll hand you over to Heather. I'll ask if you would please keep yourself on mute throughout the presentation. And the reason for that is so that any noise from your home or office doesn't interrupt the quality of the recording. There will definitely be the opportunity for you to ask questions at the end of the session. If you have to go before the session finishes, please type your question in the chat and I'll make sure that I read it out for you. The recording for the session will be sent to you after the session, hopefully by the end of today, but possibly tomorrow. And of course, you can view all of our sessions on our YouTube channel, which you can access just by Googling MAG YouTube seminars, or if you have a login to our Cowercon booking platform, in the menu on the side, you can click on seminars and educational resources. So once again, thank you so much, everyone. Thank you, Heather Kerley, over to you.
Thank you, Michelle, for the introduction. Thank you, everyone, for joining today. As Michelle said, I head our Queensland and Northern Territory abuse law teams, and I'm just one of many who are very passionate in this area. I might start off with a bit of an introduction about our teams and what we do. So, as I said, I'm one of many. Our teams comprise of lawyers, paralegals, and legal assistants who are very privileged to support survivors of abuse in pursuing civil compensation claims. We have teams who specialise in each jurisdiction, so we're aware of the nuances in particular states and territories, which really allows us to address these and the particular needs of clients in that jurisdiction, whether that might be in the territory, for example, where we frequently travel and see clients face to face in country and remote areas, really to ensure that they can access justice that they might otherwise not be able to because of remoteness or resources. And everyone in our team works exclusively in this area and are immensely passionate about it. So that's a little bit about me and my team. But more importantly, who are our clients and what do their legal claims relate to? I'm hoping that what I cover today will really be helpful for legal professionals on the call, but also hopefully some tips for any experts on the call and feedback we've received from clients who go through this claims process. And as Michelle said, I'm really happy for any questions at the end as well. So who are our clients and what do their claims relate to? Our clients come from all walks of life and a range of ages, ethnicities, life circumstances, and cultural backgrounds. We represent clients all over Australia, as I said, and although each client is unique, unfortunately, they do share one commonality in that they are a survivor of childhood abuse. Now, what that abuse might be differs from client to client. Obviously, through the Royal Commission, we saw a lot of reports of child sexual abuse, and that is a dominant proportion of the work that we do. But we also represent survivors of serious physical and associated psychological abuse as well. And unfortunately, some clients who have a combination of the two or the three. Abuse might be institutional, so that may be abuse occurring in schools, religious institutions, out-of-home care, for example. But we also represent survivors of non-institutional abuse who bring claims against relevant perpetrators and individuals. And that's quite commonly in a family setting, a relative or close family friend or other individual. Now, these claims that we bring, we don't run redress claims, but we do run civil claims, and they're really compensation and accountability for our client survivors. Obviously, there's a financial component for the loss and injury that they've suffered and continue to suffer as a result of their abuse. But a big part of what we do is also accountability and getting acknowledgement and apologies for our survivor clients as well. Now, these are some statistics from the Royal Commission, which I find really interesting. So what this reflects is the proportion of survivors who participated in private sessions and where the abuse occurred for those particular survivors. What you'll see here is almost half, so 41% of survivors who participated in a private session experienced abuse in out-of-home care, and that was closely followed by schools. I find this interesting because it is really in keeping with the clients that we represent, certainly across the Northern Territory and Queensland, in terms of the clients that we see come forward wanting to bring compensation claims. Even more recent claims that we're seeing come through sort of post Royal Commission, so 2019, 2020, those types of years, this is still quite in keeping with the statistics we see in our teams. So for survivors of childhood abuse, there are unique challenges with medico-legal assessments. I'm fortunate in that I worked in general personal injuries law before specialising in abuse law, and whilst there are some challenges with assessment overall, I do believe that there are some unique assessments with survivors of childhood abuse specifically, and so I wanted to address some of those first. So firstly, from the outset, our team explained to survivor clients that they'll need to undergo a medico-legal examination and what that is. We do try alert clients to the fact that they'll likely need to undergo more than one, particularly if we can't agree on a joint examination. Now, these appointments are often one of the most confronting hurdles for our clients during the claims process. It's something completely foreign to them, something they haven't been through before, and it's very different to a treating appointment, as you would know. In particular, for our clients, them having to recount the details of the abuse, particularly in a great level of detail, often brings distress and long repressed emotions that they've bottled up. This part in particular is really, really difficult for a number of survivors. In addition to that, which is the first bullet point, there are 3 other key challenges that survivor clients have outlined with us throughout the years of representing them. Those are having an expert who's suitable to assess them, the expert being aware of background information relevant to the client and also preparation. And lastly, the fact that the appointment is an interview rather than a treatment session, say that they're used to with a counsellor or a psychologist. And I'll go into each of those in a little more detail. So firstly, having to disclose and discuss their abuse with a stranger. Despite all the qualifications and how professional all of our experts are, you are a stranger to our clients. Often the assessment is the very first time they would have heard of you or are speaking to you. And for many clients, that is quite confronting. Many survivor clients have ongoing shame about their abuse and have disclosed the abuse to very few people, if any. It's not uncommon for myself or other people in my team to be told, you're the first person that I've ever told about this. And we can't take that for granted, and we can't take that, with a pinch of salt. It's something very serious for our clients. With the medico-legal process, it's very different to discussing the abuse with their lawyer, for example, or someone in their legal team. And that's predominantly because they've had the time to build rapport, establish boundaries, and develop trust with their legal team. Now, often through the medico-legal process, survivor clients just simply don't have the opportunity to build that same relationship, and that can be a significant challenge during the medico-legal process. The second hurdle is what I like to call the belief factor, or the perception that the expert will be looking to discredit a client or a survivor. Now, I'm sure we've all heard a client raise a similar story in the past, where, I'm going to be interrogated, or the expert's looking to find a hole in my story, those types of comments. Unfortunately, clients do often hear horror stories, are quick to Google, or know a family or friend who's gone through this process, and unfortunately can come to the assessment with some preconceptions about what it may involve. And particularly if the expert doesn't display empathy during the process, or the client feels that they're not believed, that can be really challenging for them during the assessment. This is particularly so if the client has had the unfortunate experience of being blamed for the abuse, which quite often we do see with perpetrators, or being dismissed if they did try to seek help or report the abuse. So again, I really emphasize that the belief factor is really important for our clients during these assessments, and without it, it can trigger distress, nervousness, defensiveness, and hostility, which really doesn't facilitate the medico-legal process for the client or the expert. This belief factor also draws on the fact that for many of our clients, disbelief has been the theme that has allowed the abuse to be perpetrated, often over a period of time. So it is really important that during this process, clients do feel like they're believed. The third challenge is having a suitable expert. So different clients will be comfortable speaking to different experts, whether that's male or female, or experts from different cultural backgrounds, depending on their experience. It's really important, particularly that lawyers are aware that there isn't a one-size-fits-all approach, and you need to have discussions with your clients about who might be a suitable expert early on in the claims process, particularly when many experts are booked out for several months at a time. Some survivors will prefer face-to-face appointments, which again can be a challenge, particularly if you have a client in remote locations. I have been fortunate, for example, in the Northern Territory, I have a number of clients who live in Katherine or Alice Springs, and Michelle and other people have been very kind in facilitating experts travelling. So it's always worth having those discussions with your relevant provider, but having a face-to-face expert can sometimes be a challenge. And similarities between the expert and the perpetrator can also be a challenge and a consideration. And that's something that I find not everyone always thinks about. It could be something as simple as, is the name of the expert, the first name, the same as the perpetrator? That might be particularly triggering for a client, and might not be something you turn your mind to straight away. Does the proposed expert have similar physical characteristics as the perpetrator? If so, they might not be the best expert despite their experience or qualification. Are they going to get the best out of the client for that assessment? Possibly not. All of these are things that you should canvass with your client early on. The fourth challenge is briefing material. Now, triggers are something that's really important to consider, and something I'll talk about a lot during this presentation. Our office actively try to inform the expert of any particular triggers or concerns for our survivor clients ahead of the assessment, including any literacy concerns. Now, this might be as simple as, my client finds the perpetrator's name X particularly triggering. Our office accommodates this by using the pseudonym Y. Advising the expert of little things like that ahead of the appointment can really help the client during the process. Another thing is literacy concerns. As I mentioned, a lot of our clients do have literacy and numeracy difficulties. They may be too embarrassed during an assessment to say to an expert, I don't understand that term or that word that you've asked me about. They may have difficulty completing paperwork. Advising the expert of these types of concerns ahead of time in your briefing letter can really just alleviate the stress for the client, but also allows the expert to better prepare ahead of the appointment as well. Now, some other feedback we've received from our clients is that they can often find it confronting when experts know information about them and they don't know how they've come across that information. We make an effort, and I do recommend that you inform your survivor clients of how the expert will be briefed ahead of time. So, the expert's going to have a copy of your statement, so they will already know a bit about your background and the abuse and what's happened. They will also have your school records and your medical records, so they may ask you questions about that. It's really helpful for the client to understand where that information is coming from and that they don't feel like there's a bunch of professionals talking about them, so to speak. It can also be really helpful for the expert to explain that to the client when they're asking them questions. So instead of saying, I noticed that there was a lot of domestic violence in your home, the expert could simply say, in your school records, I saw your teacher noted domestic violence. Can we talk about that? It just gives the client context about where that information has come from. Now, those four factors that I outlined really comes from client feedback that we've received over the years before and after medico-legal assessments. And it highlights some of the challenges survivors experience and the importance of eliciting information from survivors with care and sensitivity. Now, this is particularly relevant, obviously, for medico-legal assessments, which are a significant point in a survivor's claim. But really should be considered in all instances when you're having to consider obtaining information from a client survivor, particularly traumatic information. So now I wanted to discuss how we can best elicit evidence from abuse survivors in a sensitive and trauma-informed way. Now, the first thing I wanted to start with is cultural awareness. Our firm strongly advocates for professionals working in this space, both legal, medical, and otherwise, to seek out and engage in cultural awareness training, not only as a one-off, but as a regular and ongoing basis. I can't tell you the amount of times I've done a refresher cultural awareness training and I've learned something new that I didn't pick up before, I didn't retain before. It's really so invaluable and can really make a big difference to the way you and your clients engage with one another. So I'm a strong advocate for that, firstly. This is also particularly important, though, when we know our First Nations people have not only experienced and continue to experience intergenerational trauma, but continue to be at a greater risk of involvement with systems that facilitate abuse, including the out-of-home care space and youth detention. So there does need to be particular considerations and cultural awareness when engaging with our First Nations survivors. Now, I don't proclaim to be an expert in this area. First of all, I do strongly recommend that you engage an expert who's qualified to provide cultural awareness training. But I did just want to share some of the tips and considerations I've learned over the years, particularly growing up in the Northern Territory, but also through cultural awareness training that I have done. So first of all, you need to consider women's and men's business. So for example, for some clients, particularly male clients, discussing details of their sexual abuse may only be appropriate to discuss with another male. So you need to check with them whether they're comfortable having a female solicitor, whether they're comfortable having a female medico-legal expert, or do you need to make changes so the client can facilitate that in a culturally safe way. You need to consider whether there's any sorry business. So have you arranged a medico-legal appointment, but unfortunately there's been a death in the community and sorry business will be occurring during that time? Consider whether it's appropriate for that assessment to continue, noting that sorry business in some communities can go on for several weeks and the client may not be best placed to proceed with an appointment during that time. So being aware of what's happening for your client and in their community is of particular importance. Allow space for silence. And I'd really encourage everyone to have a look at Dr. Miriam Rose's foundation. She provides some really helpful information about allowing space for silence and not feeling the need to fill the void. Us lawyers are immensely good at talking and feeling like we need to fill the space of silence, so to speak. And she really advocates against that, which is something I recommend as well. And one of the expressions she makes through her teaching is that we have 2 ears and 1 mouth. We should therefore be doing twice the amount of listening. Now, that's a statement that has just really resonated with me, and I've tried to implement in my practice in this field, particularly with our First Nations clients. As much as possible, try to utilize open-ended questions rather than yes, no, or closed questions. Consider whether there's any need for an interpreter and make sure you arrange that well ahead of time, noting for a number of language groups, there can sometimes only be a handful of interpreters in the entire country who are qualified to interpret, and they can be booked quite far in advance. Consider eye contact and whether that's appropriate. So for some groups, direct eye contact and persistent eye contact can actually be quite disrespectful. So for some clients, you might see them look around or look at the floor or the ceiling or whatever it might be. And that doesn't mean that they're not engaged in the process or that they're being disrespectful, but rather there could be cultural considerations there. So just be aware of that. Be mindful of not using the names of deceased persons without permission. Again, check with your client, and this might be deceased relatives, for example, if you're getting a client's background or family history, particularly of parents or siblings, but it can also be the perpetrator. So check with the client if there is someone who has passed away, how it's best appropriate for you to refer to them and how your client would like you to refer to them in the legal context, but also during a medico-legal examination. And lastly, but most importantly, is don't be afraid to ask the client what their preferences are and what they need. There are numerous distinct nations throughout the country, and it would be incredibly difficult for all of us to be across all of the nuances of each. But our clients are the best experts in what they need. So giving them the space to communicate that and giving their voice is really important. Ask them what they need and they will tell you throughout the process. So setting the scene. Before meeting and speaking with survivors, consider the environment the conversation will take place in. So how is your meeting space organised? Is it welcoming and open? Is there artwork or visual displays? Are they appropriate, for example, or may they be triggering for a client? I never forget, I'll tell you a story. I never forget a client who I met with, and it was during a settlement conference. And the whole time during the conference, I could see that she was diverting her eyes elsewhere past me to a picture that was on the wall. I thought she just wasn't very interested in what I was saying, which may be true as well. But what it ended up being when I asked her was that the picture on the wall had a striking resemblance to her perpetrator. Now, it wasn't the perpetrator, and it was just simply a poster that was on the wall. But for her, she was disengaging through the process because of that visual trigger. So we removed that poster, and it's like we had a new client in the room. So being really aware of what's in the space, but also the cues that your client is providing, verbal and non-verbal, can make a big difference. Consider whether your survivor client will be able to leave the room easily and see and access the door. For some survivors, they may feel most comfortable closest to the door where they know they've got an escape route if it gets too much. Or for other clients, they may prefer to face the door so they can see who's coming in and make sure the environment stays safe. Have water, tea, and coffee available, and make sure you let your survivor know of the location of the bathrooms and how to access them. And also consider whether the survivor can channel their nervous energy. This might help alleviate anxiety for some survivors. So have a fidget spinner there, have a stress ball, have a pen available that they can tap in their hand or against their leg, or a piece of paper that they can scribble on. Somewhere for them to channel that energy can make a big difference as to how they feel during that process. Your preparation. Now, we all hear that preparation is key, but I can't emphasize that enough, particularly for these clients, both as lawyers, but also for medico-legal experts on the call. Review any documents which can assist in limiting the extent of questioning, particularly about the abuse itself. Make sure an appropriate length of time has been allocated for the meeting. Allow for breaks if necessary, particularly if the survivor is likely to become quite distressed, and allow ample time to establish rapport. In particular, for experts, I know your time is often brief with our survivor clients. As much as possible, I really advocate for reading your brief ahead of time where possible. We know these briefs are often quite large and there's a lot of records for these types of claims. Unfortunately, one of the most distressing things that we can find for clients is when experts cancel appointments last minute because they've realized how big the brief is, for example. And that can be particularly traumatizing for a client who has worked themselves up for that day. So being as prepared as possible can really make a big difference to how the appointment is conducted for the client. And lastly, consider your body language and attire. Avoid closed-off postures such as crossed arms, which might be perceived as hostile, and make sure you're engaging with the client through active listening and in an empathetic way. Building rapport and fostering engagement. So as I said, if in doubt, ask the clients what their preferences are for discussions. Keep in mind that these clients have had their autonomy violated by virtue of the abuse. And so it's important to make sure that they feel as empowered as possible and we're giving them as much choice every step along the way. Now, doing this will reduce stress levels and help foster positive engagement. So, for example, if you're meeting virtually, check that the client's comfortable to speak freely. You might do this by saying, "Are you somewhere where you feel safe to talk today?" This is particularly important when we know the literature around early childhood trauma and the predisposition to further risk and abuse later in life. Many of our clients who have experienced childhood trauma have also experienced subsequent abuses, whether it's further sexual or physical abuse, domestic violence, and the like. It's really important that you're asking from the outset that the client is somewhere that they feel safe to talk about what you're talking about that day. If meeting in person, in addition to the tips that I've already outlined, keep in mind that the client may not like any unsolicited physical contact. This might be as simple as shaking a hand, which so many of us just automatically go to do, but really asking the client's preference before you do so is key. It may also be things like a number of us have fallen into the trap of when a client is quite distressed and wanting to console that client, whether it's a simple pat on the shoulder, for example. For a lot of clients, that can be quite terrifying and re-traumatizing for them. So making sure that you're considering that in any physical contact as well. Again, check with your client regarding any triggers, whether that's a name, a word, a place, for example, and how these can be mitigated as much as possible. And discuss short breaks and breathers and let the client know that they can take one when and if needed. In addition to the previous slides, really important to explain the scope of the assessment or your meeting with the client. So this simultaneously applies to experts and legal professionals. So before an appointment with a client, say, "This is what I want to talk to you about today. This is the agenda. Is there anything there you don't feel comfortable about talking about or isn't okay talking about today?" Again, it's about giving the survivor that choice throughout the process. For medico-legal experts, us lawyers explain as much as possible what to expect, but often clients are so nervous in the lead up to the appointment or the day of the appointment, a lot of that can completely go out the window. So again, explaining to them what to expect during the appointment with you, what types of questions will be asked, whether you'll need to discuss the abuse in detail or not, how confidentiality will apply, and also whether you'll be taking notes, why you will be taking notes, and how they will be used. Again, as much as possible, and I appreciate certainly for our experts that time is limited, but if you do have the time to build rapport and establish some boundaries and trust, particularly around the sensitive matters, and before you jump into the details of the abuse, it can make a big difference to the client's experience of a medico-legal assessment. Make sure survivors are aware that they can ask questions and give them ample opportunity to do so. Bear in mind they may be too nervous to interrupt you during the process to ask a question. So making sure you give that space and allowing for the silence that I mentioned earlier on as well. Again, if in doubt, ask. This is extremely validating for survivors and comforting in and of itself. It demonstrates care and consideration on your part, and this can go a long way towards fostering a safe and positive interaction for the survivor. This is particularly important for medico-legal assessments too, where you have only a brief time with the client. So again, giving them as much choice during that process. Now, for our legal professionals on the call, you then need to consider how you're going to manage ongoing and regular contact with your survivor client. Again, asking and noting their preferences. So do they prefer to talk face-to-face, over the phone, or via email? For a lot of survivors, I hear, for example, that when I have to say it out loud, it makes it real again. I prefer if we could just email. So asking them and they will let you know. If they need to meet with you in person, do they have a preferred location for doing so? So is a conference room in your office particularly triggering for them? Is there somewhere else you can meet, whether that might be their home, their park, or their counsellor's office, for example? So showing flexibility in terms of locations. Would they prefer that any abuse-related or difficult questions be put to them verbally or in writing? So that might be if you need to discuss details of the abuse, maybe you've had some questions from the defendant that you need to answer. Would the client prefer that you send that to them ahead of time so they can consider that and be prepared? They might be able to reach out to a support person to make sure they're there with them. Or would they prefer not to have that notice because they'll dwell on it and it'll make it worse for them? So again, considering that and asking them ahead of time. What is their preferred frequency of contact? So do they want to be contacted every week, every time you have an update, no matter how big or small, or would they prefer to be contacted as little as possible? And lastly, do they have preferred days or times to be contacted? Are there any specific dates that they would prefer not to speak with us? For example, does their family know about their abuse? Do their children, do their wife, do their husbands know about the abuse? If not, they may prefer that you only contact them during work hours, for example, when they're not at home. Do they want you to avoid contacting them around birthdays, for example, anniversaries? And this might be particularly important for our First Nations clients who are also members of Stolen Generations. So considering these key dates and anniversaries, diarising them where possible to make sure you're not reaching out to clients on dates that might be particularly distressing for them. Now, despite all your best intentions, there may be times where things still don't go well for your client. And that's pretty understandable given they are a survivor of abuse. No matter how many safeguards we can put in place, it is likely still going to be distressing for a survivor to go through this claims process, including the medico-legal process. So what I wanted to outline here is recognising some signs of client shutdown and when they might need a break. So as I said, even with the best preparation, you may catch a survivor on a bad day or a time that they might be subject to triggers beyond their control, or it may just be that the particular subject matter that you need to discuss that day is quite distressing for the client. I recommend that you look out for signs of a survivor shutting down. These might include a survivor avoiding eye contact, but again, be aware of any cultural considerations. It might be quick yes, no, or abrupt answers to questions, indicating that they're just looking for the conversation to end as soon as possible, which could also be demonstrated by I don't know as a response to questions quite often. And lastly, your survivor client exhibiting signs of restlessness or distress. If you think a survivor might be shutting down, and you'll know this the more you interact with your client, you might like to check with them by saying simple things like, "It seems you may be shutting down a little," or "Can you tell me where your mind is at the moment?" And they might just say, "That word you said there triggered me," or "I've had enough for today." "You seem a little distracted at the moment. Is now still a good time?" Or "Have you had enough for today?" Again, these simple breaks to regroup your client may be enough to bring them back into the conversation, or enough for both of you to recognize that the conversation's really reached its limit for that day, and you're better placed picking it up at another time. A number of our survivor clients also experience suicidal ideation or mental health crises as well. Many, if not all of our clients will present with mental health conditions, at times substance abuse issues as well. Now, if you're interacting with a survivor who you believe may be at risk of immediate or imminent harm to themselves or others, these are just some bullet points that I'd really strongly advocate for you to consider. As much as possible, and early on in the conversation before the client deteriorates, note their location and contact details as much as possible. They may not be willing to provide this to you later on in the discussion, particularly if they are actively suicidal. So getting that information as soon as possible is critical. Ask the survivor directly if they're having thoughts of harming themselves and or others. I've done this a number of times, and in my experience, the client will tell you, and that just simply allows you to gauge the level of risk and the steps that you need to take. If thoughts of harm are indicated, advise the survivor that you're required to let emergency services know in order to keep them or someone else safe. And as much as possible, keep the survivor engaged, whether that's on the phone or in person, until emergency services arrive. Now, I know myself and a number of people in my team have really had to use these steps and crisis services for clients. We've had clients attempting suicide whilst we've been on the phone with them. And having these notes and having crisis support services readily available has made a huge difference during a number of those calls. So I do strongly advocate for this. Now, in less urgent situations, you may have a survivor who's highly emotional, and this may be how they are generally during all conversations, or particular conversations such as when you need to discuss the abuse itself. Showing empathy as much as possible towards their feelings and acknowledging that it's okay for them to have the emotions they do is critical. Active listening, again, not feeling the need to fill the silence, but do concentrate on what they're saying, understand and respond thoughtfully. Be patient. A number of our clients will not explain their story, for example, in a linear fashion. It will be here, there, and everywhere, and you may need to piece that together. But giving them the time and the space to do that and being patient so they can feel heard. Reassuring that you are there to help them, support them, and again, believe what they're saying. Again, that belief factor is incredibly important, but also showing professionalism and recognizing your limits. Many of us in this space, want to console our clients and make sure they're okay. But certainly in the legal professional space, we're not qualified to provide ongoing psychological support, for example, for a client. So it's really important, again, that you have those referral pathways open if needed, and you can get that help for your client during the claims process. Now that brings me into my next slide, which is engaging with other support services. As I said, we're legal, well, most of us on the call are legal practitioners, and we're there to assist the client with their legal matters. We're not qualified in providing psychological support or counselling. To this end, I strongly advocate that professionals build a contact list of local support services in their area or their client's area that can be readily accessible, particularly when you're on the phone with the client. It's also important to know how to make a timely referral to these support services. How do they accept referrals? Is there a wait list? I spoke to one counselling service this week who have a 6-week wait list, and that's really important to be able to inform the client of when you're making that referral, so they're not expecting that call the next day, for example. It also helps you triage what support services are going to be appropriate in different circumstances. And consideration should be given to linking a survivor in with these services early in the claims process, provided they consent. This can be particularly important during key stages of their claim, such as the medico-legal process, where a lot of clients might find that quite distressing and re-traumatising. So can you contact their psychologist and arrange an appointment, immediately after the medico-legal appointment where they can debrief? Can you arrange an appointment the next day after a court appearance, for example, where the client can have that support service available and also know that that's in place ahead of time? Now, those are the key points that I wanted to cover today. As said, I'm very happy to take any questions if there are any. And for anyone who's not comfortable raising any questions on the call, I've also included my contact details, which you're very welcome to reach out directly as well.
Oh, Heather, thank you so much for what truly was a very informative and well thought out presentation. From the point of view of my role as the National Manager of a medico-legal provider, I've got some takeaways for that I'll be talking to my team about, but also talking to our abuse panel of specialists about. And one of the interesting takeaways, I just want to list these for others listening, was that you spoke about the size of the brief and a doctor, cancelling an appointment at short notice because of the size of the brief. That happens so often. And I think that I would urge practitioners and people, when they're making a booking, if they think the brief is going to be large, to give the provider a bit of a heads up about that. And that way the doctor can exercise their right to perhaps decline, but also advise of any fees they might have for excess reading, but also suggest that perhaps they might need an appointment a couple of weeks down the track because due to their clinical commitments, they're going to need more time to prepare. And I thought that was a really great takeaway. The other one you mentioned was amongst the triggers of, perhaps the psychiatrist or gynecologist, for example, might in some way resemble the perpetrator. And I really liked that as something that should be certainly thought about. I do recall a matter where there was a person who had an issue with the colour red because they had walked in on a suicide and all they could recall was blood, and red was a trigger for them. And we had to remove red things from the office and the waiting room. And the last one that struck me, of course, was the interpreters. And many, many years ago, I worked with in refugee status for the immigration minister, and it was extremely important. Not only could you not, for example, go and pick an Arabic interpreter, sometimes it mattered that not only was that Arabic interpreter perhaps either a man or a woman, depending on the gender of the injured person, but also that they might be from the same ethnic group, and particularly not an opposing ethnic or religious group, which could curtail the person's ability to be forthcoming. So look, I really loved those takeaways. Anyone, do you have some questions that you would like to ask of Heather? If you do, you can unmute yourself now and ask away. Although that was pretty comprehensive. Here we go. No? Well, that's great. That's really good. I have to say all the things that I thought I was going to perhaps ask or raise, you did cover.
Good.
That was just excellent. So everybody, thank you for making time to join us today. As I said, you will receive the recording of this hopefully this afternoon, but definitely by tomorrow. And of course, we look forward to seeing you at our next seminar. Thank you again to Heather Kerley from Maurice Blackburn Lawyers for speaking with us today. Everyone have a great rest of the day.
Thank you for having me.
Ta.